Let's talk about why. There's a piece by Emily Bazelon in Slate, I think it is, as to why you should care if Dzhokhar Tsarnaev has his Miranda rights read. And we know, and we talked about this briefly last week, I think it was on Tuesday, Monday or Tuesday night, where a former FBI agent on All In, Hayes' show, had said they won't be read their Miranda rights because of the public safety exception. Now, understand that 1966, the Supreme Court said that suspects in a criminal case, and remember, this will be tried in a criminal court. Suspects in a criminal case need to be read their rights. They need to know what rights the Constitution grants them. The right to remain silent, the knowledge that anything they say can be used against them in a court of law, the right to have an attorney. And in 1984, there was a case that the Supreme Court of the United States heard that carved out an exemption to when a suspect needed to be read his or her Miranda rights. It was in the context of a case where a man was suspected of rape. The victim said that her assailant had a gun. The guy had an empty holster. And so the cops had every reason to believe that the guy did have a gun, that it was somewhere else. And for the sake of public safety, before they Mirandized him, they asked him where the gun was. And the exception was allowable, and anything they found in terms of finding that gun was still admissible, because someone could find that gun, shoot themselves. Someone could find that gun, shoot someone else. There was a public safety exemption here. In 2002, the FBI messed up, apparently, the interrogation of Zacarias Moussaoui, the 20th 9/11 hijacker who never got onto the planes. Former FBI Special Agent Colleen Rowley wrote a memo pleading, the quote, that if prevention rather than prosecution is to be our new main goal, an objective she agreed with, we need more guidance on when we can apply the Quarles public safety, Quarles was the case in 1984, public safety exception to the Miranda's Fifth Amendment requirements. So in other words, we needed to know that in that instance that we had the ability, because there was an imminent threat to public safety, to not Mirandize this guy. Following the apprehension of the Christmas Day bomber, the FBI invoked the public safety exemption and interrogated him. They stopped the interrogation after 50 minutes. They then Mirandized him after getting what they said was valuable information. The suspect then asked for a lawyer, stopped talking. Later, he ended up did talking with his attorney after being Mirandized and gave them valuable information. But a significant period of time later, after he was treated at the hospital. Then you had the Times Square bomber. He was interrogated without Miranda warnings. The FBI claimed it did get useful information. Following the time that he was then Mirandized, he kept talking. At that time in 2010, following holders at the Justice Department wanted the Congress to take up a bill so that he had statutory authority to expand this exemption to the Miranda rights, to expand the definition of public safety to something that was not imminent. You may recognize that that conceit. We see that now with who is an imminent threat in terms of being chosen to be assassinated by drones or any other means, I guess, that matter. Congress did not take up this measure, so the Department of Justice wrote a memo essentially expanding this exemption on their own, unilaterally. It's never been tested, never signed off by a court. There may be exceptional cases in which, although relevant public safety questions have been asked, agents nonetheless conclude that continued unwarranted interrogation is necessary to collect valuable and timely intelligence not related to any immediate threat, and that the government's interest in obtaining this intelligence outweighs the disadvantages of proceeding with unwarranted interrogation. The courts may yet have the opportunity to do this. The FBI may, in fact, harm their chances of getting a prosecution if they go beyond what a court would find reasonable in this instance. But remember, this is setting a precedent. Every time we do something like this, it is setting a precedent that gets expanded and expanded. We know from reporting last week or the week before in McClatchy that the drone program is no longer and has not been used solely for people who represent even an expanded definition of imminent threat to the United States. It is used essentially as a bargaining chip where we offer the services of using our drones to assassinate other people on behalf of other governments to get things from other governments that we want. Maybe it's intelligence, maybe it's, I don't know, rights to do a pipeline. I mean, who knows if it can be considered national security. This is the way that you expand the destruction of these rights. It doesn't happen at once. It happens bit by bit by bit.